The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. Court from recess, now sitting.
Please be seated. Good morning to everyone. I would ask Mr. Doug Shima to please call the 10:30 docket.
The first case on the 10:30 a.m. docket for Thursday, November 2nd, 23. Appeal number 126478 in the matter of Sarah E. Johnson, original action and attorney discipline, no briefs filed.
May it please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. I'm present and ready for argument.
Second case is appeal number 126479 in the matter of Leon J. Davis Jr., respondent, original action and attorney discipline, no briefs filed.
May it please the court, Kathleen Seltzer-Lippert on behalf of the office, present and ready for argument, would request 3 minutes.
3 minutes is granted.
May it please the court, Leon Davis, respondent, appears in person and with his attorney Trey Petlin. We are present and ready for argument.
Final case is certified court reporter number 1721 in Ray Megan Rogers, matter and court reporter discipline.
May it please the court, Todd Thompson appearing as appointed disciplinary counsel for the Board of Examiners of Court Reporters, ready for argument and would request 3 minutes for rebuttal.
3 minutes is granted.
Court Brian Smith appears on behalf of Megan Rogers, and Megan Rogers appears in person as well, and we're ready for argument.
Your Honor, that concludes our 10:30 docket.
Thank you, Mr. Shima. I would note for the parties and those who may be watching through our live stream that we do have an empty chair this morning. Justice Biles is under the weather, but he is watching via the live stream, can communicate with the other justices via email, and so he may send a question in if he does have one. And he will be participating in our resolution of this morning's cases. So just to clarify that. We'll now call 126478 in the matter of Sarah E. Johnson. I know only a few seconds have really passed since Mr. Shima called the docket. Ms. Johnson made no appearance then, but one more time I will ask if Sarah Johnson's in the courtroom. Seeing no response, Mr. Vogelsberg, whenever you're ready, you may begin.
May it please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. Since Ms. Johnson hasn't appeared, I will not be requesting rebuttal time. This is original action in attorney discipline involving respondent Sarah E. Johnson. Ms. Johnson was admitted to the Kansas bar in September 2001. Ms. Johnson's law license was administratively suspended in September of 2021 due to her failure to pay for the annual registration fee. Her license has remained suspended since that time. The ODA filed its formal complaint against Ms. Johnson on February 17th of this year, alleging that Ms. Johnson committed rule violations in 6 separate disciplinary complaints that were filed against her. Pursuant to Rule 215A, the ODA mailed the formal complaint and notice of hearing by certified mail to Ms. Johnson's registered business and residential addresses. The mailing sent to the business address was returned to the ODA on March 6th with the notation returned to sender, unable to forward. The certified mailing sent to Ms. Johnson's residential address was returned to the ODA on April 6th with a notation that it had been returned as unclaimed. Additionally, the ODA sent copies of the formal complaint and notice of hearing by regular mail and by email to Ms. Johnson. The ODA did not receive any indication that those mailings were not delivered to her. Ms. Johnson ultimately failed to file an answer to the formal complaint, and she failed to appear for the disciplinary hearing that was on April 18th. Highly summarized, the evidence presented at the hearing established that based on the timing of when the ODA started receiving disciplinary complaints against Ms. Johnson sometime in early 2021, Ms. Johnson abandoned her law practice, which was focused on doing criminal appellate work. She abandoned numerous retained and appointed clients, which resulted in the 6 disciplinary complaints being filed against her. After the hearing, the panel issued its final hearing report on June 5th, concluding that Ms. Johnson violated 1.3 diligence, 1.4 communication, 1.16 termination of representation, 3.4C knowingly disobeying an obligation under the rules of a tribunal, 8.1B knowingly failing to respond to a lawful demand for information in connection with a disciplinary matter, 8.4D conduct prejudicial to the administration of justice, and Supreme Court Rule 210 duty to timely respond to a request for information. At the conclusion of the hearing, the ODA recommended that Ms. Johnson's license be suspended for 30 months and that she be required to undergo a reinstatement hearing under Rule 232. The hearing panel recommended that Ms. Johnson be indefinitely suspended. This case was docketed with this court on June 16th. That same day, the clerk of the appellate court mailed notice to Ms. Johnson by certified mail to her registered residential and business addresses, notifying her that she had 21 days to file exceptions to the hearing panel's report. Ms. Johnson never filed exceptions, so pursuant to Supreme Court Rule 228G, the findings of fact and conclusions of law are deemed admitted by Ms. Johnson, and so the only issue before the court today is what sanction to impose upon Ms. Johnson.
Let me ask you, when you sent those to her, is there proof of receipt, or did you also get notice that they were undeliverable?
The clerk's office sent those. And
Oh,
due to
okay.
the recent security, I'm not able to access
Okay.
the return receipts on those.
Got it. Thank you.
I would also mention that on September 14th, this case was scheduled for today's oral argument. And on September 19th, the ODA sent letters by regular mail to Ms. Johnson's registered residential and business addresses and email letters to her registered email address, plus also a personal email address that we had discovered during the course of the investigation. The letter notified Ms. Johnson about today's oral argument. The letter mailed to Ms. Johnson's business address was returned to the ODA as undeliverable on September 28th of 2023. The letter mailed to her residential address was never returned, so presumably that letter was delivered. And then also the ODA did not receive any bounce back notifications regarding the 2 sent out regarding today's oral argument. So presumably Ms. Johnson has received notice of today's hearing. Given the rule violations that were found by the hearing panel and Ms. Johnson's failure to appear today, the ODA will ask the court to adopt the hearing panel's recommendation of indefinite suspension. This court has recognized in prior cases, including N. Ray Barker, 302 Can 156. It's a 2015 case. That a respondent's failure to appear for oral argument can be considered an aggravating factor, which may warrant imposing a sanction greater than that recommended by the ODA or the panel. The ODA would ask the court to apply Barker and impose an indefinite suspension in this case. Unless the members of the court have any questions for me, I would waive the remainder of my time.
Was there some other information or evidence suggesting that at least the respondent was aware of the investigation? I read that there was at least some communication, some indication of maybe some ADHD or whatever, but some interaction. Was that with your office and Ms. Johnson or the investigators?
During, the investigation, she had sent a response by email on July 12th of 2021 regarding the first 3 complaints that were filed against her, specifically in her response concerning DA 13689, which was a complaint that was actually submitted by Mr. Shima regarding her conduct in 3 cases that she was appointed to represent defendants before this court. She had identified issues, mental health issues, as contributing to her inability to comply with the deadlines established by the court.
Thank you, Mr. Vogelsberg.
Thank you.
Court will take this matter under advisement. I will now call 126-479 in the matter of Leon J. Davis Jr. Respondent.
It please the court, Kathleen Seltzer Lippert on behalf of the disciplinary administrator present and ready for argument.
You may proceed.
This is an original action involving attorney discipline. Mr. Davis was licensed to practice law in Kansas in 20. Comes to the Supreme Court by way of summary submission, where the parties have agreed to the facts, rule violations, aggravating, mitigating factors, and a joint recommendation for a sanction. Highly summarize the basic factual background in this case. In December of 2019, Mr. Davis was arrested for DUI after employees at the Taco Bell drive-thru contacted law enforcement. In January of 2020, he was charged with felony DUI. He has an obligation to report felony charges. He did not report those felony charges as required within 14 days. The disciplinary administrator's office learned of the felony charges about a year and a half later when the prosecutor's office provided that information to our office. Subsequent to that, he did provide a written response with the assistance of counsel. He entered a plea to the felony DUI on November 17th of 2022. He did report that appropriately within 14 days. On December 5th, 2022, this court entered a temporary suspension based on his felony conviction pursuant to Rule 219 G1. And then subsequent to that, the parties entered into the summary submission agreement, agreeing to rule violations, aggravating and mitigating factors, and a joint recommendation. With respect to the joint recommendation, it is the party's request of this court that temporary suspension be lifted, and then after it's lifted, would impose a 2-year suspension, but stay that suspension and place him on 2 years or 24 months of probation.
Can I just jump in here and ask the question that's on my mind, which is earlier this morning, we had a case in which a lawyer had a disorganized practice and had failed to follow up on some cases and failed to prepare a client accordingly. And your office asked for a 3-year suspension to be stayed. And now we have a felony DUI that's not reported. We're asking for a 2-year suspension. So help me square that circle.
Sure. I'm not familiar enough to speak to the previous case, but I can certainly speak to this case and the thought process that went into this recommendation. So the ABA standards certainly talk about when conduct is knowing that a suspension is appropriate. And the term of that suspension depends on a variety of factors, aggravating, mitigating factors, and of course the specific facts in the case. A couple of cases, I guess, in reviewing and looking at this case, I think are helpful. In 2019, the Henry Cure case, which is 309 Kansas 877, this court looked at a number of felony DUI cases. The facts are a little bit different in each one because each one is unique and individual, but clearly this court noted that felony DUI is a serious violation of the attorney's primary duty to the court, the bar, and erodes public confidence in the judicial system. And this court also noted that varying sanctions imposed are based on a careful consideration of aggravating and mitigating factors in this case. With respect to this situation, that's one of the, I guess, serious aggravating factors. because it's two rule violations, which is noted in the aggravating factors that there are multiple violations. Failure to report the felony charges. In fact, never reported the felony charges. It was reported by the prosecutor. And then, of course, the conduct, the felony DUI, driving while under the influence, which of course is dangerous to the public and so forth. So those are some of the aggravating factors. Also, in this particular case, the respondent, because he was temporarily suspended, he has been suspended for, it's coming up on a year. It's not quite a year. The temporary suspension was imposed December 5th of 2022. And so that is significant and I think important. The probation that was outlined, I think, is serious and creates the opportunity to go forward, protect the public, and to assist the respondent in making changes that are necessary so that rise again. Does that?
Thank you.
And another question I had in relation to just the summary agreement and past conduct, reportable conduct. By implication, a DUI, felony DUI infers, depending on which statutory scheme we're dealing with, 2 prior convictions for a DUI or a diversion and a conviction for a DUI in the past. What happened with those? Don't you have to report those too?
So there has been a change in the rules and that partly explains it. So with respect to this case, and that's, I guess, as I will explain, I think that plays into the ultimate joint recommendation here. The respondent incurred a DUI in 2009, which was before he was licensed to practice law. He did disclose that on his bar application.
Thank you. Okay, I was wondering how far back we're going. And when was the other one?
Sure. The second DUI occurred in 2014. It was a second offense. I believe the plea was actually in 2015. And a DUI second is an A misdemeanor. Now in the rules changed, I believe, January of 2021. And one of the rules that were modified in 2021, historically, at least since 2011, attorneys have been required to report when they're charged with a felony and or convicted of a felony. Prior to the rule change in 2021, there was not the requirement to report an A or a B misdemeanor charge or conviction. Subsequent to January of 2021, the rule was modified and now there is a duty to report the A or B charges or conviction. But in 2014, 2015, when the respondent's DUI second occurred, that the specific requirement of reporting charges for A or B misdemeanor was not a requirement.
I appreciate the clarification. I didn't appreciate the history there because okay, thank you.
And I have a question. In paragraph 12 of the summary submission, the parties agree that respondent was under the mistaken belief that he was obligated to self-report only after he was convicted. So under the ABA standards, it's either intentional conduct or repeated negligent conduct. So would this be negligent conduct that wasn't repeated?
I would submit that knowing applies, although the parties didn't specifically agree. Knowingly certainly applies to the actual conduct of driving while under the influence. But I would reflect on—
But it was a separate, but you charged him with a separate violation for failing to report, correct?
Yes. So the separate violation is based on the former rule, Rule 203, subsection C, subsection 1, which required attorneys to report felony charges within 14 days. That rule, I believe, was effective or has been effective since 2011. The respondent was licensed in 2013, so it was effective prior to—
But I understand he violated the rule. The question is, did he violate that rule knowingly or negligently?
So as a licensed attorney, you have a duty to know the rules of professional conduct. And the rule it didn't change midstream for him. It was actually in effect before He was licensed as an attorney. So the joint recommendation, placing him on 24 months probation, or impose lift the temporary suspension, impose 2 years, place him on 24 months probation. The respondent did file, as required in 227F, a affidavit of compliance thus far with his probation terms. He provided our office with information supporting his compliance with the probation that he's able, with the probation terms that he's able to comply with, because the probation terms contemplate that he would come back to practice and require monitoring and supervision of the practice and some other terms. But with respect to his treatment and compliance with treatment and evaluations and abstinence, he has complied with those terms.
When did that begin? When did the compliance begin? How long has that been?
I
so
want to say
far?
April of 2023. It was, I think, the same date that the summary submission was submitted. I believe that's April 24th, but I may have the exact day wrong, but April of 2023. I would.
Thank you.
May it please the court. I'm Trey Petlin. I'm here with Leon Davis, the respondent in this case. On December 18, 2019, my client arrived at a crossroads. Unfortunately, he reached his crossroads in a Lincoln while he was driving while impaired. Back then, he was a functioning alcoholic. Somehow his practice was not affected. He wasn't missing hearings. He wasn't neglecting clients, but he certainly was teetering on the edge of becoming a non-functioning alcoholic. Michael Balancio, who is my client's KLAP monitor and his practice supervisor, reached out to me yesterday. He had written he was sorry he could not be here today. He wrote I think, a insightful letter, which was Respondent's Exhibit E1. When I began reading that letter, my first reaction was, whose side are you on? But he certainly wasn't immediately convinced that my client was invested or that he would succeed. And it was clear from the letter that he was not going to give my client a free pass. Davis was going to have to, in fact, change his life. I haven't read Mr. Balancio's letter. There is a happy ending. He describes my client's transformation as miraculous. Mr. Davis dove headfirst into AA. He found a group that included several lawyers, including lawyers who did criminal defense, that were there to mentor him and help him. He's been meeting with them frequently, much more than the probation would require, initially several times a week. He rose to be the vice president, and he's currently serving as vice president of his chapter. It's a 2-year term. Over the nearly 4 years that Mr. Davis has arrived at that crossroads, he has redefined that time in his life as rock bottom. That'll obviously be a lifelong challenge, but he has, to this point, made that his rock bottom. He's been on supervision and monitored for alcohol use since January 15 of 2020. He's been monitored through pretrial supervision, regular meetings with his pretrial supervision officer prior to his conviction, random urinalyses, remote breath unit, which was a condition of his bond for a while. And during house arrest, 2,160 hours of house arrest, he had daily phone calls for random UAs. And he did not have a single non-compliance. His substance abuse evaluation, which is Respondent's Exhibit C, goes into some of his background. He served in the Navy. He went combat zones twice. The evaluation identifies a couple points that I think are not unusual, but that are notable for our purposes. Number one, prior to my client's third DUI, he did not think he was an alcoholic. Thought he had bad luck. And Mr. Davis, like I think just about everybody on planet Earth, has had tragedy in his life, but he coped with his tragedy and his anxiety, even his anxiety related to the practice of law, with alcohol. Became a daily drinker. Mr. Davis enrolled in substance abuse treatment and mental health treatment to address grief, to address the triggers, to address anxiety, but also substance abuse issues specifically. He entered into a KLAP agreement in June of 2020. Renewed that agreement February of 2023. He formally accepted responsibility for his actions in his criminal case November 17 of 2022. He was sentenced, that's Exhibit M, Respondent's Exhibit M, on February 21 of 2020. Since the incident back in December of 2019, he's arrived at some milestones as a result of his sobriety. He has completed 3 full marathons and 6 half marathons. On October 21 of this year, he ran a marathon in 4 hours and 39 minutes, which was, he took an hour off of his time from 2021. So it's amazing what Mr. Davis can accomplish when he's not drinking. As of December 5, he will have his Ms. Seltzer-Lippert pointed out, he'll have 1 year of suspension. So this morning, I'm asking the court, I'm joining her office and recommending a 2-year suspension stayed to give him an opportunity to complete 2 years of probation. Mr. Davis would like to address the court just briefly.
Morning, Leon Davis. I am the respondent in this case. I wanted to start off by just thanking everyone that's helped me through this process. Been a tough process, but you know, it was necessary. And my family, my friends, my colleagues, Trey, my lawyer, everyone has just done so many amazing things and showed me the support that I have and what I can do when I'm not drinking. And I'm just so happy to be here today to talk about being sober and being healthy and about trying to refocus my energies on something more constructive. I mean, I'm so sorry. There's not even words that can really state how sorry I am for all of these actions. It's not becoming of an attorney, and it's certainly not something that I want to be known for. I'm very, very grateful, you know, for this process. I understand why we need to have lawyers that are healthy, that are out there doing things for the public. And I'm asking, put some trust in me and to earn the privilege back someday. I don't know when it's going to happen, but I want to earn the privilege back to be a lawyer. It's not my right, it's a privilege. And I hope that by continuing these meetings, continuing to run, take care of myself, I know that I can be healthy, that I can be there for my clients. I genuinely care about them. And it's very difficult not being able to represent them in court, especially for decisions that are choices that I made. So I'm so thankful for the process, for the consideration that you all give to our requests. And I hope that one day that I can be a Kansas attorney.
I would waive rebuttal unless there are questions.
The court will take this matter under advisement. Thank you. I will now call CCR number 1390 in Ray Megan Rogers.
Good morning, Todd Thompson appearing as special disciplinary counsel for the Board of Examiners of Court Reporters in this matter involving reporter Megan Rogers. This matter involves a failure to timely deliver a transcript for an appeal that involved the severance of parental rights. There were repeated failures. The complaint was filed. There was no response to the complaint. And at the hearing on this matter, the respondent did not contest any of the alleged facts and did not, as the board noted, present any evidence justifying the delay. The board found a violation of Rule 9.F2 for professional incompetency. There was also an allegation of a violation of 9F3 for misleading or untrue representations by the reporter. And there was no comment one way or the other in the board's report. The board did.
The board didn't find her that she had violated any rule except for competency, correct?
Correct.
So the fact that there was no response filed, there was some confusion about that, wasn't there, as to whether she where the response would have gone or whether she received it and when she received it? Wasn't there some confusion about that?
Not that I'm aware of. There was no confusion at the hearing in terms of her admitting all of the factual allegations.
Well, I'm not talking about the formal complaint. I'm talking about the original investigation, which apparently led to because she filed a response after less than a month after the formal complaint was filed, correct?
Not within the 20-day period, no.
But
You're talking about the original complaint or the formal?
The formal complaint.
Yes, she did file a response to the formal complaint.
And the original complaint, there was some confusion over whether she received notice of that or when she received it and whether she responded, because she testified that she responded to that, didn't she?
She did not testify that she responded to the original complaint.
On a piece of notebook paper that was possibly sent to Ms. Raymond or to someone else?
There was no evidence at the hearing on the formal complaint to that effect.
But she wasn't found to have been in violation by failing to cooperate with the investigation.
Correct.
Thank you.
And there was also no finding of a violation of 9F3 about making misleading or untrue statements. There was not a finding either way. There was no mention of that in the board's report. The board
What does that
recommended.
mean there's no finding either way?
I'm sorry.
What does that mean, no finding either way? I mean, are you here asking us to consider that allegation?
Yes, I am, as I did in my brief.
But you have
On what basis? Sorry. On what basis? Again, I think
Go
I
ahead.
anticipate Justice Wilson's question. If the burden of proof is on you and it was not carried because there was not a finding of a violation, how do we consider it?
The facts that were admitted indicate that the transcript was allegedly completed to the degree of 85% by the 1st of September, and that only 15% remained to be done. And yet it was not turned in until February of the next year.
Yeah, I guess I'm not asking about the substance, but just the procedure.
So I think what the question is, that you charged 4 violations in the complaint, and then at the conclusion of the formal hearing, the board only found 1 violation. And so, did you file any exceptions to the board's lack of finding of violations below? How would those other 3 violations be before us?
Because the board makes a recommendation and the facts are before you. So you can apply the facts and the allegations of the formal complaint in determining the proper discipline in this matter. So all of the information that you would need is before you, and you are the body that ultimately determines that issue. The board does not ultimately determine that issue. Board makes a recommendation.
Based on its findings of rule violations.
Based upon its findings. And its findings are that all of the facts were admitted and that no evidence was presented justifying the delay.
Right, but you charged her with making misleading, deceptive.
I did, and I proved facts which I believe absolutely prove that she made misleading representations to the court in claiming that this transcript was 85% complete by the first part of September.
So the problem is just you don't have the fact finders, the lower tribunal agreeing with that. You don't have a finding.
We do
of a
have the
violation.
facts. We have all of the
But you don't
facts.
have a finding of a violation. You don't have a conviction. Just, I know we don't speak in terms of convictions, but that's what you don't have.
You are correct, but they don't make convictions. They make recommendations.
Well, they make recommendations with respect to.
Make
Just the-
findings about violations.
But they do make, right, I mean, is that wrong from your perspective?
It is my opinion that they look at the facts and that they make recommendations based upon their
As to-
interpretation of the fact.
As to both rule violations and recommended discipline.
Correct.
Okay, let's talk about that then in the context of the rule violation. She testified that she thought she was 85% complete with the transcript in September, correct?
Correct. Well, she
And-
didn't, she actually put that in her motions.
And you didn't present any evidence to refute that, correct?
I would disagree. We presented evidence that it was not completed until February of the next year.
But you didn't present any evidence to refute the 85% estimate, correct?
No,
And
other than the fact that it didn't get done in September, it didn't get done in October, it didn't get done in November, it didn't get done in December, it didn't get done in January. That extra 15% didn't get done until February.
And she testified that her computer crashed. Is that correct?
I believe that she had a number of excuses, yes.
And
Said
did
she
you,
changed
did you,
jobs?
did you present any evidence to refute that her computer crashed?
I did not.
She also was working with Best Buy for that, correct?
We don't know.
Did she testify to that?
She did.
And did you present any evidence to refute that?
Other than the timeframes, no.
I didn't see in the transcript any evidence that there was a criticism of the transcript that was presented.
That's correct. It was accepted and used. But the competency issue had nothing to do with the ultimate transcript. It was the timing issue.
So it was only the time issue that you're alleging it was late and that it shouldn't have been late.
Correct.
She changed jobs also.
Not until September or October, according to her own statement.
And was there some testimony that it was more difficult for her to get information from Shawnee County because of the change of job?
Sort of.
There any, as I read the transcript, I saw no testimony to refute that, correct?
I saw no testimony that I would call solid testimony that explained that and how that was an exceptional circumstance, which was her duty under the rules and under the court's order, was in asking for extension, she was to state and explain the exceptional circumstances. And her statement about Shawnee County didn't have any meat on the bones.
But the Court of Appeals was satisfied that she should have those extensions to the extent of granting it until October 22nd. Is that correct?
They extended a number of times with the caveat or the express direction that there shall be no more extensions. And then they gave another extension and another and another. The first few were except for exceptional circumstances. The last several extensions did not even include that option, the exceptional circumstances. They said there will be no more exception or extensions, period. And those directives were still not met.
Is there any evidence presented as to what a different court reporter would have done given the difficulties that she presented?
Other than the board, as you know, has panel members who are court reporters and
they questioned her also. But
correct.
my question is whether there was any evidence presented by a different certified court reporter as to what they would have done given the difficulties that Megan Rogers had in completing the record.
We did not engage an expert witness to review the facts and opine on that because frankly, there's no hypothetical information there of such a solid nature that an expert could opine. The mere statement that I changed jobs and I had computer problems and went to Best Buy, in my opinion, did not warrant hiring an expert witness to opine on that.
Did they warrant a finding of mitigating circumstance?
There is no finding of mitigating circumstances.
I'm asking whether you submitted, whether that should be considered as a mitigating circumstance.
Whether what should be considered.
The computer crash, any difficulties she may have had in getting information from Shawnee County because she had a different job. Apparently she testified as needing emergency surgery and also having her children home because of COVID and obtaining COVID herself.
She made those allegations. I did not, frankly, contest the fact that she was at home, the fact that she changed jobs.
So you would have considered that to be her job to present those as mitigating factors?
Yes, I think so. I have no time left. Does anyone have any additional questions?
You'd like to make a recommendation to the court?
I have recommended in my brief that the court accept the recommendation of the 6-month suspension that was made by the board after it heard all of the evidence. I would note that that's a couple of months shorter than the amount of time that this family had to wait to get this transcript, and the transcript being 8 months, delivered 8 months after it was originally due. So acceptance of the board seems very reasonable to me.
there any presentation of damages that may have been cause of the delay?
In terms of
The hearing,
at the hearing,
yes.
there was no evidence other than the fact that a 6-year-old and two of his
That presented at the hearing.
that this involved 3 children and their mother and the severance of parental rights. Yes.
In the transcript?
In the transcript of the hearing,
Transcript of the hearing below in this case. Was the underlying case mentioned?
I do not recall. Anything else?
Questions from anyone? Thank you.
Morning, Chief Justice Lukert, Justices of the Supreme Court, Brian Smith appearing on behalf of Megan Rogers, and Ms. Rogers is here to my right. First of all, Ms. Rogers would like you to know that she has been honored to be a part of the profession as a court reporter, wants to remain as a court reporter, Kansas. And there was a delay in the filing of this transcript. It was certainly due to extenuating circumstances that have been presented in the record. I do want to touch on Justice Wilson's first questions about the testimony of the first letter that was given about a complaint. There is in fact testimony in the transcript provided to the court on pages 16 and 17 of the transcript. Question: now you received a letter from the board advising you the complaint had been filed sometime either in real late 2020 or early 2021, correct? And the answer was, I believe so. I'm on page 17 now. And the letter asked you to submit a written response within 30 days, correct? And the answer was, of which I did. Question: can you tell the board how that response was allegedly sent? Answer: I hand wrote a response the first time and mailed it back. I never received anything back, but I had to handwrite it as we were there in quarantine the last of January, right after my emergency surgery at the end of December. So her testimony was that she had responded to the original letter complaint. She also filed a response to the formal complaint. This case takes place in the backdrop, justices, of the COVID emergency. And I would ask the justices to think back to Administrative Order 2020 PR 16 issued by Chief Justice Lukert, which found that in order to determine, it says, as Chief Justice of the Kansas Supreme Court in consultation with members of the Kansas Supreme Court, I've determined the following actions are necessary to secure the health and safety of the court, users, staff, and judicial officers. And basically there were several orders. And the last one that strikes out to me is, other than jury trials in progress, all district and appellate courts, administrative offices, the offices of the clerks of the district court and appellate courts, and court services officers will be restricted to emergency operations until further order of the court. Now, it went on to provide that one of the items that was an emergency operation was any other appeal, motion, or original action requiring expeditious resolution. This case was on appeal, and my client did in fact file a number of requests for extension of time, all of which were granted. So the argument that somehow my client is incompetent because she requested additional time that were requested, that
How
were
many,
granted
how
by
many
the board.
requests for extension did she file?
There was 5.
Five?
Last one allowed for a response on October 22 of 2020, which she did not file it by that date, which triggered the show cause.
June, August,
September.
September.
That's 4, and that was the last one. And then the 5th is the order where the court says, please.
So then she filed an out of time motion in September because she didn't even make the,
Right, granted.
okay, and then the complaint was filed. Okay, so she filed 5. So just, this is not in the record, but based on my experience as a Court of Appeal judge who worked on the motions panel, arguing that the motions were granted, they're always granted. That they get 10,000 motions a year. So that's, they grant the motions. What are they going to do? Deny it? I mean, it's not going to make it any more ready. The only leverage that a motions panel has is to report, to discipline. I mean, you just don't have any leverage when a court reporter keeps asking and asking. So I'm just saying that that's not a good argument. So I'm not persuaded by this. And this is, to me, this is very troubling because it is. This is an expedited case. I don't know what else she had going, I did not read the transcript. So, but I don't know what else she had going on, but an expedited case for us, even when we have an expedited case, everything goes to the side because that's what expedited means. This is a termination of parental rights. Every day that a kid spends out of home counts. So this is a 5 or 6 month delay, maybe even longer, of getting these transcripts. And, she, I asked opposing counsel, she's saying very general things. Number one, she says in one, I'm finalizing. And then the next one, she says, I'm 85% of the way done. What does that mean? I'm finalizing and I'm 85% of the way done. And then another one just says, due to personal circumstances. No, she says to finalize edits. So she doesn't even say to finalize, like, I want to do the other 15%. She says to finalize edits, which clearly implies I'm done just editing. I think this is really troubling. And part of it is, I'm going to tell you, based on my experience of, you're down there and you're getting these, rote motions that they're just filing. And it's particularly troubling in expedited cases. So I would like you to continue with your argument, but know that I'm troubled by this. And I do want to hear what you have to say.
Yes, Justice Stanbridge, and you point out a great structural issue that exists within the court system as it relates. Part of the evidence in this case is my client left employment with the Shawnee County District Court and took up employment in the Douglas County District Court. The day you leave as an employee of the Shawnee County District Court, your passwords are canceled, your email, your e-filing is all canceled for that particular court. When you take employment in a different district court, you then that all has to be reinitiated. This occurred during the middle of the COVID shutdown.
When did she transfer employment?
September of 2020.
Okay, so this is how late, what in September of 2020 is when she filed her 5th
Correct.
motion for extension.
Right. So they were out of the office, generally working remote from March of 2020. They returned in July of 2020. She worked at that time for Judge Anderson, who was being appointed as chief judge, and they were moving chambers, as typically takes place in Shawnee County. So her records were boxed up, and she was moving. Then once they moved in July, then she changed employment in September and went to a different district. She did testify in this case that her computer did go down. She offered to the hearing board, the disciplinary board for the court reporters, to provide the Best Buy receipts and evidence, of what she had to repair. She ended up having to buy a whole new computer. That the transcript that was being worked on her computer, she had to start basically back over. I also note that she estimates that the transcript was 600 pages long. It ended up being 651 pages long transcript. This was a pretty substantial transcript. And one other response to you, Justice, that I think is answering the question of what power do you have other than to grant the motions? You know what the Court of Appeals had the power to do? The same power that every other court has in the state of Kansas to issue a show cause order, which is what the Court of Appeals did. And what they indicated was if you don't file the transcript by February 8th of 2021, you need to appear and show cause why you shouldn't be held in contempt. This transcript was filed on February 5 of 2021. So she was able to get it filed. 85% estimate.
Can you tell, I'm
Yes.
sorry, I don't mean
No,
to
no.
cut off your responses to Justice Standridge. But I had a question about our rule interpretation, professional incompetency. Is that a simple negligence standard, or what does that mean? Have we had an opportunity to interpret the meaning of that term?
Well, you have to pull from attorney discipline cases. There's not very many court reporter discipline cases. And the one case cited by by Mr. Thompson was one involving the failure to respond to a motion for summary judgment. You know, ultimately, my client did respond and file what was requested. And ultimately, it was before the deadline for.
Under threat of a show cause order and discipline. That's what it
Well,
took.
The show cause order is not necessarily discipline as a court reporter. It means the court may sanction
Same difference.
a person or a litigant. And it
Under
also-
threat of sanction.
It also provides that the court the court shall hear the matter, I'm just reading from KSA 620-1204A. One of the caveats says the court shall hear the matter at the time specified in the order, and upon proper showing may extend the time so as to give the accused a reasonable opportunity to purge oneself of the contempt. So there's even it's allowed within the indirect contempt procedure that the court, even at that point, can give someone more time within the discretion of the court. Our suggestion in our brief is that requesting additional time and that's granted is not a sign of incompetence.
So so I get it straight in my
Yes.
mind, to summarize your position here before us today is, one, the transcript was not filed late,
Ultimately, it met the last deadline that was set.
not late.
Right.
And two, you're asking us to find no rule violation.
Well, we could have done a better job. Bottom line, my client could have done a better job. Now, mind you, this is in the midst of a pandemic with a lot of moving parts.
Okay,
'Cause
but just to cut to the bottom line, are you asking that this court determine that there was no rule violation, or are you conceding a rule violation?
we would ask the court, we suggested that they did not meet their burden in our brief of finding.
That's what I read. I just
That's
kind of wanted
correct.
to nail
Yes.
it down if that's what your position
That's correct.
still is.
That no finding, and particularly no finding of rule 9F3.
Well, no, I'm focused on 9F2.
Yes,
Which
that's
is
in
what they
9F2,
did.
because Mr. Thompson was the prosecutor. He's not a member of the board. And he was not one of the parties that voted on the finding. And the only finding was one of incompetency. And
Which
in
you
our-
disagree with.
correct.
Right.
And then our next request is if the court's going to find incompetency, that what the court does is admonish her. That she could have done a better job, and next time, let's do a better job.
And I guess
And-
my question earlier
Yes,
is we could have done better. It sounds like is not your definition of professional incompetence, but is it a simple negligence standard? Like,
Competence?
did the respondent deviate from a professional standard of care? Is that enough? If the answer is yes, is that enough to support an F2 violation?
See, I don't.
Or does it require something more? That's what I'm
Require
trying to
something
understand.
more. That's why the court has rules that allow for an order of contempt to be issued, and then the court, within the court's powers, either can find contempt or in fact give the person additional time to correct whatever error they have. And what your honors do not have, and before you don't have anything that suggests that the case that was on appeal was decided differently because of the delay. There's no information that the transcript was not acceptable, meaning it was acceptable, meaning it was of sufficient quality and in nature that it could be utilized by the Court of Appeals. We don't even have before your honors any testimony about that the outcome was changed. If the
Well,
court's
under-
upheld,
I'm sorry. I
no,
don't
no,
mean-
please, Justice.
Underlying facts supporting any conclusion of incompetence must be proved by clear and convincing evidence,
Right.
correct? So was there, to Justice Standridge's point, she was still employed by Shawnee County until September.
Yes.
And presumably had access to her records at least until she changed employment or until her computer crashed. And so until such time as it became difficult for her to access her records, is there clear and convincing evidence of incompetence? Or
I don't believe so.
to support incompetence?
was
What
back to
evidence is
Justice's-
there?
Justice Wall's question, what's the definition? And they have to have standard of evidence of clear and convincing.
Well, was there evidence presented to show that she should have done a better job when between April of the hearing and I believe it was pronounced to be expedited in May or May of 2020, correct me if I'm wrong. So between May and when the records were not accessible to her, there evidence of what, I mean, how along the something that could support the finding that she should have done a better job. I mean, what do we have?
You have the testimony of my client, her answers to the questions of Mr. Thompson and the board. You have there's not even a point in where any part of the transcript was talked about in the hearing that said, well, on page 64 of the transcript of the underlying hearing, it's gibberish. You've seen that. Yeah, I mean, we've all tried to read court reporter records. We all date back to the date when it came on a strip of paper and the court reporter could pull up the phonetics and none of us could read it, but they could read it. She does this where they speak into it. And so it transcribes it while she's talking into it. But again, it's kind of gibberish that she understands, but you and I wouldn't be able to understand it till it's typed and reviewed. And there's no evidence was presented at the underlying court or the underlying hearing of when did she access the file. They should have that evidence. There's a specific rule, and I cite it in our brief, of exactly what's supposed to be retained by the clerk of the district court of records of hearings. And it's supposed to be an electronic format. It's supposed to be the exhibits. I mean, it's all there. And then in its native form, which is going to be the recording, the verbal recording, along with the voice interpretation by a software program that she ultimately has to clean up and make it make sense to all of us.
Can you clear a factual situation? I'm reading from the board's findings.
Yes.
So she files this out of time motion for extension of time on September 28th. That's granted, and she has until October 22nd.
Right.
Okay, but she doesn't file it until February?
So nothing is filed after after October 22nd. She doesn't file a motion. Doesn't file the transcript. Then the Court of Appeals enters an order in January, show cause order, that says you need to produce the transcript by February 8, 2021, or show cause why you shouldn't.
Right, but if the last extension granted to her was October 22nd.
Right.
Then she's in violation from October 22nd on. I mean, the show cause order doesn't count as an extension.
Didn't suggest it did. What I suggested was there's a process to find someone in contempt if they don't adhere. to
Right,
the
but
order.
you said requesting additional time is not a rule violation. You said it was never late. You said it was not late.
Right.
It was late.
Ultimately, she complied with the last order of the court in this
Right.
case.
Well, no, but she filed it. The last extension that was granted was October 22nd. So October to November to December to January. I mean, she was 4 months late without asking for any extension of time, true?
Was after October 22nd, there was no further order on the
No
deadline
request,
until-
no order. She drops off yeah.
Correct. And
Okay.
in her transcript is the testimony of what was going on medically with her. She had an emergency surgery after Thanksgiving and in fact, she testified she was even in quarantine for exposure to COVID when she finished this transcript and brought it over and delivered it.
But October 22nd to Thanksgiving is still a month.
651 page transcript, yes.
Is there any evidence presented as to how long this transcript should have taken to produce by an average court reporter.
Thank you for answering all my questions.
I am completely out of time and overtime. I have no further comments unless any of the justices have a question. Thank you.
Okay,
We would
thank you.
request that you first make a finding that there was no rule violation. And if you are going to find that there is a rule violation, that the correct discipline would be an admonition, not the 6 month suspension, and certainly not the additional 2 months that council has asked for. If you read the brief, the last paragraph says you should add 2 more months onto the discipline recommended by the board. We would suggest that you disregard that as well. Thank you.
Several of the motions for additional time were tardy, were out of time. This was supposed to have been turned in at the beginning of June. The transcript was. It wasn't turned in June. It wasn't turned in July. It wasn't turned in August. It wasn't turned in September. And in none of those months, is there any testimony of any mitigating circumstance like a change of job or illness?
Was there evidence regarding the standard of care in terms of the timing of preparing or producing a transcript of this 600 whatever pages in the record?
There was not. Again, an expert witness brought in, and part of the reason for that is because several members of the board are court reporters. I would quote this court, that quote, "Repeated failure to timely respond is clear evidence of incompetence." That's from the Dennis case. I would also note that while at the hearing, there was a suggestion that perhaps Best Buy documentation could be presented at some future date, it was not presented by respondent. I would also note that there was an increase in the number of days needed. First tardy request was for 14 more days, and that then went to 20, and then that went to 30. So that 15% was starting to require more and more days. And then I think someone said fell off the face of the earth. There was just no comment in the last of October, November, December, January. And the court took the initiative, the Court of Appeals did, of issuing a show cause order. The fact that the respondent asks for dismissal of this and says that she did nothing wrong, I think requires that her attention be gotten by the discipline this court imposes. And we would again ask you, as we did in the brief, to adopt the board's recommendation of a 6-month suspension. Are there any final questions? Thank you.
You. Court will take this matter under advisement. Court is now in recess until tomorrow morning at 9:30 a.m.